They actually set a trial date. I'm surprised. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. So I was having some technical difficulties earlier today whenever we were live streaming the court hearing, the scheduling hearing in the Idaho versus Bryan Kohberger case. But it doesn't really matter because the whole thing maybe lasted like 15-ish minutes. They didn't really accomplish too much when it came to agreeing to anything really in the session itself. As it turned out, there was a scheduling recommendation, right, sent over to both parties last Friday. And that's basically the same thing they discussed today in court, which probably could have been handled outside of court and was probably handled via email before session even started. What I'd really like to know is how much today cost the state. How much did the taxpayers pay for this unnecessary court session? This whole entire case is costing way more money than it should. Today's court hearing was a huge waste of time, money, energy, and like all of the resources that go into these things. Plain and simple. If I were in Idaho, especially a Latah County taxpayer, I'd be throwing a fit and demanding answers on some things. But we actually have an official filing that was filed today at 11:09 and 36 seconds Idaho time. And we know that Idaho time, the hearing actually started at like 10 a.m. So this would have been posted less than an hour technically after everything finished. So now we have the trial setting. It states that a jury trial shall commence at 8:30 a.m. starting on June the 2nd of 2025, and that it will run until August 29th of 2025 on an 8:30 to 3:30 p.m. schedule. Trial will not be held on June 19th, which is Juneteenth, or July 4th, obviously 4th of July. These dates are inclusive of jury selection as well as any sentencing phase that may be necessary. The defense's motion to change venue is currently set to be heard on August 29th of 2024. If that motion is granted, the court anticipates the trial dates will not change, although the location of the trial would. And see, that doesn't make any sense at all. Because you're basically saying that if there's a change of venue that's accepted, which we do have that still coming up, like they just said, all of this stuff with the trial is being set and we still have the whole change of venue motions to go through. So I don't know how they can say, oh, it's going to be the exact same dates, even if it gets switched to a different location. How do you know what any other court has on their schedule? Or are you just expecting them to accommodate you for your high profile case because their location is chosen for the change of venue to cancel everything that they have going on for your court case? That's not really how it's supposed to work. So I can pretty much bet you if the change of venue gets approved, this is going to end up getting changed. These dates are going to be changed. The final pretrial conference will be held on April 30th of 2025 at 10 a.m. So that will be the very, very last court date before all of the stuff with the actual trial finally gets started. Any motions challenging the death penalty shall be filed on or before September 5th of 2024. So that's this year. Trial is supposed to be next summer, but anything when it comes to challenging the death penalty has to be filed soon, like in the next 2-ish months or so. Any responses shall be filed on or before October the 10th of 2024. Any replies are due by October 24th of 2024. A hearing on the motions shall be held on November 7th of 2024 at 10 a.m. Motions to suppress evidence and any other 12B motions shall be filed no later than November 14th of 2024. Responses shall be filed by December 19th of 2024. Any replies shall be filed by January 10th of 2025. A hearing on the motions shall be held on February 6th of 2025 at 10 a.m. and may continue until February 7th of 2025 if needed. Motions of limine, including any 404B notices, shall be filed by February 13th of 2025. Any responses are due by March 13th of 2025. Any replies shall be filed by March 20th of 2025. A hearing on the motions shall be held on March 27th of 2025 at 10 a.m. and may continue until March 28th, 2025 if needed. So they're basically saying if you are going to exclude the IGG, Mr. State Santa Man, like you've been saying that you're going to do this entire time, even though you've allowed all of this bullshit, okay? If you're actually going to file for it to not matter, your motion for limine has got to be filed by February 13th of 2025. Now, what's going to be so insane is if they actually file it. And again, as a taxpayer, I'd be throwing a freaking fit, okay? They have allowed how many thousands of billable work hours, whether it be investigative, whether it be the attorneys, whether it be the people that work in the attorney's office, whether it be outside sources, whether it be courtroom time, okay? How many thousands of billable hours and how many hundreds of thousands of taxpayer dollars has been put into all of this IGG bullshit? Whenever the state has been saying from the beginning that they were going to literally file this to make it inadmissible and not important. They've allowed this to continue. They've made it really clear, at least towards the beginning of this, that the strength of their case against Bryan Kohberger relied on the DNA of that knife sheath. Okay? So for them to have just allowed all of this insanity over the last 18 months and then a couple months before trial, oh, we're going to snag it all away. We're going to make all of it completely irrelevant. Does that do good on both sides? Because as far as I can understand, the defense is really questioning how the DNA got there. So if they decide to file this motion of limine, what else does the state actually have, considering that we're hearing that everything location and time specific to the crime is missing pretty much? What are they going to have if they actually file this motion of limine? Nothing. That's how it sounds right now anyway. They would have absolutely nothing. Discovery completion. The state's discovery deadline is September 6th of 24, and the defense's discovery deadline is January 9th. Wow, that's a big difference. And I think we've heard this already, but it looks different whenever you're reading it. September of this year is the last date that the state has in order to have like any admissible evidence actually submitted. The defense, Bryan's team, has an additional, how many months is that? October, November, December, January. Like 4 months. That's crazy. That's crazy. Disclosure of trial experts. A list of experts, along with a copy of the expert's report, consistent with ICR 16b7, and a copy of the expert's curriculum the state intends to call at trial, shall be disclosed to the defense and the court by December 4th of 2024. A list of experts, along with a copy of the expert's report, consistent with ICR 16c4, and a copy of the expert's curriculum the defense intends to call at trial, shall be disclosed to the state and the court by January 9th of 2025. So again, the state's deadlines are first, and then the defense has a little bit of additional time after the fact. Any rebuttal experts for either the state or the defense by January 30th of 2025. Trial materials. Proposed jury questionnaires shall be provided to the court by February 7th of 2025. Responses must be filed by March 7th of 2025. Pursuant to ICAR, and then lists a whole bunch of rules, a closed sealed hearing on the jury questionnaires will be held on April 2nd of 2025 at 10 a.m. So whatever questions is actually on the jury questionnaires, we won't be privy to. I mean, obviously, after the fact, we kind of get to see all the stuff, but this is going to end up being a closed session. And that's the only closed one that they've mentioned so far, at least specifically. Proposed jury instructions shall be filed with the court by March 14th of 2025. Jury instructions will be discussed at the final pretrial conference. Lay trial witness list shall be filed by March 14th of 2025. Your regular old people. Exhibits list with attached copies of exhibits shall be filed by March 14th of 2025. Each party shall prepare a list of exhibits that it expects to offer, excluding impeachment documents, to the court and to opposing counsel. Exhibits should be listed in the order that the party anticipates they will be offered. Each party shall affix labels to their exhibits before trial. Oh, you shall be organized. You shall. You have the court's permission to not just stuff stuff into a folder completely out of order with no date and time stamped on it, with no actual label on it whatsoever. Now you have the permission to get it together, be an adult, and be organized. Now. So stupid. The state's exhibit should be marked with red labels in numerical sequences with an S before the number. Example S-1. Defendant's exhibits should be marked with blue labels in numerical sequence with a D before the number. Example D-1. The case number should also be placed on each of the exhibit labels. You mean like it should have been on all of the pieces of evidence, but we're hearing that it was otherwise? Their disorganization in this is probably what threw me for the loop the most, honestly. Exhibits should be lodged and served as required by this pretrial order. Exhibit labels can be obtained from a deputy court clerk. Counsel shall provide a copy of each exhibit and an exhibit list to opposing counsel and the court. Copies should be made after the labels are marked and attached to the original exhibit. To expedite the trial, each exhibit to be offered should be viewed by opposing counsel prior to trial and a determination made as to whether an objection will be lodged against the exhibit. So they're telling them to show each other your own evidence, because we're going to need to know ahead of time if somebody is going to object to something or not. I thought that all had to happen like actually in court. So they're going to present a piece of evidence knowing damn well that they're expecting to hear objection from the other side of the room the second they present it. That's really stupid. An exhibit to which there is no objection will be admitted prior to trial. Each party shall provide the court with a trial brief which shall be filed on or before March 14th of 2025. Sentencing disclosures. Any witnesses, lay or expert reports, and a list of exhibits with copies attached the state intends to present in support of aggravation shall be provided to the defense and the court by January 9th of 2025. Defendant's mitigation disclosures, including a list of witnesses, lay and expert reports, and a list of exhibits with copies attached shall be provided to the state and the court by March 3rd of 2025. Any witnesses, lay, or expert exhibits the state intends to present in rebuttal shall be provided to the defense and the court by March 31st of 2025. The court reserves the right to hear any motions filed after a deadline has passed if good cause is shown, including but not limited to motions that arise after a disclosure made by the opposing party. But that seems to be it. June 2nd of 2025 is to be, for now, because it will probably change, the first date of trial. Considering the fact that paperwork was sent over to both parties on Friday, this is all coming out and being agreed to today. I just feel like the whole scheduling motion and however much money it costs to get everybody in the courtroom today was ridiculously redundant. But let me know what you guys think down in the comments. Do you think we're going to stick to this June 2nd, 2025 trial start date? Or do you think something's going to end up happening to where it gets pushed back? I honestly feel like it's going to get pushed back, but that's just my opinion. If you guys like the way that I present this information and give that opinion, please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. See y'all.